Our next case is People versus Butler. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, and you may reserve time, but we ask that you keep track of that yourself. And I do want to say thank you both for agreeing to make a scheduling change to accommodate another case this morning. And begin when you're ready.
Absolutely. Madam Chief Justice, may it please the court. My name is Britt Cobb. With me is Julia Kelly, and we are so pleased to be here today discussing this with you on behalf of the appellant, Karl Butler. 40 years ago, in People versus Hackett, the court said that the defendant in a CSC case should be permitted to show that the complainant has made false accusations of rape in the past. And so in Hackett, the court laid out the procedure that trial courts must follow when making the preliminary admissibility determination. The Hackett procedure has protections for the complaining witness at every stage. The Hackett procedure has rape shield policy considerations factored in at every stage. So having built in layers of rape shield policy consideration and layers of witness protections into the Hackett procedure, the court should not accept the prosecution's invitation to now also require heightened evidentiary burdens of proof beyond what is normally required. Never has this court signaled that heightened burdens are necessary in this context because the Hackett procedure itself protects the witness and it protects the policy over and over again. And nothing other than a straightforward application of the rules of evidence to the Hackett procedure is warranted when making the preliminary admissibility determination. Now, in our view, the circuit court got it right here. It carefully balanced proof, prejudice, relevance, and importantly, of course, the defendant's rights when making the preliminary admissibility determination. The Court of Appeals got it wrong. It substituted its own judgment for that of the trial court and applied a standard that really just doesn't exist in any of this court's jurisprudence. We believe the court can summarily reverse the Court of Appeals on our application and reinstate the trial court's original preliminary admissibility determination, and in any opinion or direction from the court, it probably would be helpful to judges and practitioners that the court make it clear that Hackett requires the trial court to hold an in-camera hearing when there is some evidence of falsity in the offer of proof, and it would probably be helpful for the court.
There was no hearing in this case, right? No in-camera evidentiary hearing was conducted.
There was. It was on paper and on documents submitted to the court by agreement of the parties.
So the parties waived
The
prosecution in-camera evidentiary hearing?
I think they decided to do it on paper rather than by taking testimony. The parties agreed to do it that way. It was at the suggestion of the prosecutor. The court reviewed a bunch of documents in camera. They're attached to our application as Exhibit N, and the court made the determination that way.
What are your thoughts on us adopting a standard in Stanaway, which is reasonable probability?
The Stanaway standard obviously is one of discovery and not of admissibility. And I would point the court to the Court of Appeals decision in People versus Adamski, I think it is, Adamski. I don't have the site, but it's in our brief. There they talked about the stand-away procedure being used to get the medical records, get the psychiatric records, and then the Hackett procedure being used to make the preliminary admissibility determination. So I think they're really apples and oranges, because what we're talking about here are pretty standard things that judges have to do when they're performing their gatekeeping function, right? They're making preliminary determinations about conditional facts, in essence. And in every context that I've been able to find under Rule 104A, the trial courts decide conditional facts based on a preponderance of the evidence. And that really is in keeping with the important roles that juries play. The conditional fact in our context is that the prior allegation was false, right? That's what makes it relevant. And then whether or not you can prove that is different from whether it's relevant. So 104A directs trial courts to make the preliminary determination about whether there's enough evidence to send it to the jury to decide, because obviously juries are the ultimate deciders of fact, not judges. So when the trial court can be satisfied that there is preponderant proof of falsity at the in-camera hearing, that doesn't end the analysis, because we still, of course, have prejudice and policy and relevance hanging in the balance. But when there is preponderant proof, it needs to go to the jury to decide. The jury gets to hear it, and they decide the fact, because if judges decide facts based on these really high standards of proof prior to trial, it kind of turns the Sixth Amendment on its head, because then we don't have juries performing their fact-finding function. And I do want to say a word, Your Honors, if I may, about this concrete evidence standard that was used by the Court of Appeals. Prior false allegations made by complaining witnesses, I mean, they're usually going to be relevant in a CSC case, but really in any case, but especially in a case like this, where we have essentially a credibility contest between a witness and a defendant. And the prosecution doesn't really dispute the relevance of a prior false allegation, but instead what it is offering up to the court is a rule that says, in order to be relevant, a prior false allegation has to be kind of really false, right? It has to be conclusively false, demonstrably false, all of these standards that we just don't have in our jurisprudence anywhere. And I think this concrete evidence standard evolved from some language in the 1991 Court of Appeals opinion, People versus Williams. And that was a case where a young child had accused the defendant of some sort of sexual abuse, and there was some evidence that the child had previously maybe made an allegation against an uncle or something about sexual abuse. And what the Court of Appeals said was, we're not going to give you an in-camera hearing because there's not been any evidence presented in the offer of proof that this thing was false. There was some evidence that maybe the prior allegation occurred, but literally no evidence that it was false. And in essence, what the defense attorney wanted to do was put the victim or the mother of the victim on the stand to find out, to kind of flesh it out. Was this false? And what the Court of Appeals said is that we aren't going to have an in-camera hearing because there's no evidence at all that it was false. There's no concrete evidence. So and then I think what has happened is they take this language about concrete evidence, and it kind of grows into this thing that it wasn't really meant to be, in my reading of the Court of Appeals opinion in Williams, necessarily an announcement of a particular quantum of proof, just more sort of.
Do we need to overrule Williams, or is there a way that we can if we agree with you, is there a way that we can walk that back?
That we can keep Williams intact?
Yeah.
Yeah, I mean, and in fact, I don't, if Williams was meant the way I'm reading it, I don't even necessarily disagree with it. There does need to be some evidence of falsity in the offer of proof.
So do you think there were, like, a gloss was put on Williams in those cases that came after?
I'm not sure that there's anything published after Williams that upholds the concrete evidence standard as a quantum of proof. Okay. But I think to the extent that Williams means concrete evidence means some evidence of falsity in the offer of proof, not just rumor, speculation, hope that an in-camera hearing might result in some evidence of falsity. I don't disagree with that standard.
Is the perpetrator, or the alleged perpetrator of the other act, is their denial and the lack of a prosecution enough?
In my opinion, yes. But I think, especially in our case, it was kind of and, you know, we had denial by a perpetrator and denial by another perpetrator and a police investigation that didn't yield any charges, and people at the party that say, this is kind of what this young lady does.
So what if you just had, for purposes of a rule, I appreciate that your position is that that's not the facts in your case, but if you had a denial by the perpetrators and the lack of, you know, a prosecution, would that be enough in general?
In general, I would say yes. But I do think we have to trust that trial judges know how to weigh that kind of evidence and hear people, make credibility determinations. How is this story coming out from the perpetrator versus how is it coming out from the complainant? What were the reasons that there wasn't
So you
a
think it's
prosecution?
enough to even get to the in-camera for the judge to then sort of weigh whether or
Oh,
not
I absolutely think it's enough to get in camera. Absolutely. Because there's somebody saying it's false. And I think when you think about Williams and some of the other cases where they've denied an in-camera hearing, it's really just because nobody's saying it's false. There's really no evidence that it is false. But when someone is saying, no, it didn't happen that way, I do absolutely think that it should get at least in camera. Because what are appellate courts to do to review these determinations if we don't have an in-camera hearing? And you know, in-camera hearings they're private. The victim
So,
is
Ms. Cobb,
protected.
just to piggyback on what Justice Kavanaugh was asking, so is it your contention that any time someone says it's false, then that should be enough to trigger an in-camera hearing?
I do think so, Your Honor.
Okay.
I do. I mean, if there is an identifiable person that says this person is going to come in and they are going to tell you it's false, I absolutely think that should be enough to trigger an in-camera hearing. Most of these cases where we don't get an in-camera hearing, there's nothing like that. So I do think that should be enough. If you all don't have any more questions, I don't know how much time I have left, but I do.
You have 2 minutes and 20 seconds. Do you want
Well,
to reserve?
I do just want to remind the court that, you know, this is a really, really big deal for this defendant. You know, he is on trial for his life. This is a life offense. And in a credibility contest like this case will be, if the jury doesn't hear about this, he will be left without critical pieces of evidence for the jury to evaluate the complaining witness's credibility. In essence, the package that the prosecutor wants to present without this evidence is just not real. I mean, it's a nice package, but it's not really what happened. Everything from the false allegations to the reasons for delaying in reporting to the reasons for not following up on prosecution to the reasons for the complainant's mental health struggles down the road. I mean, without this, the jury just doesn't have any context, so, thank you.
Thank you.
Good morning. May it please the court. Amy Lee Shepard appearing for the people of the state of Michigan from the Kalamazoo County Prosecutor's Office. The Sixth Amendment right to confrontation only requires that a defendant be allowed to introduce relevant and admissible evidence. When a defendant seeks to introduce evidence of an allegedly false prior accusation of rape made by the victim, whether the prior allegation is demonstrably false is the threshold of relevance and necessary in order to invoke the constitutional standard of confrontation. In applying the three-step procedure this court established in Hackett, the Court of Appeals has long held that to meet the threshold of relevance to trigger an in-camera hearing under this theory, a defendant must offer concrete evidence of falsity in his offer of proof. Now, this is not a different standard than the one that this court established in Hackett. Rather, it's an application of the requirement that a defendant lay a foundation of relevance in his offer of proof. The concrete evidence of falsity standard, or a prima facie showing that the prior accusation is false, is a reasonable rule. It appropriately requires a defendant to demonstrate the evidence relevance in order to invoke confrontation. This rule allows trial courts to weed out frivolous claims based on generalized assertions, lacking demonstrable fact, from proceeding to an in-camera hearing, let alone to trial. The Court of Appeals rule, at a minimum, should remain undisturbed or affirmed by this court. In order to give full effect to the legislature's enactment of the Rape Shield statute, should a defendant make an adequate offer of proof that the prior accusation was false, this court should require trial courts to find that the defendant has met a heightened standard of proof, such as clear and convincing evidence, in order for it to be admitted at trial. Such a rule from this court would also greatly aid trial courts as they conduct these hearings. As the Court of Appeals found, the defendant has not met the minimum threshold of demonstrating evidence relevance, and there was no in-camera hearing here.
Is there a difference, or what do you see as the difference between concrete evidence and the clear and convincing evidence that you're suggesting?
So I think they're two different questions, right? So we're talking about the different steps in the proceedings under Hackett. So that first question requires a defendant to establish the evidence's relevance and to demonstrate that relevance, to state the constitutional question, demonstrate the relevance. So that's one question. The second question is then at the in-camera hearing, by what standard of proof do they have to show what they articulated in the first one? So that concrete evidence standard is there an adequate foundation to say that this is actually a false statement? Did the victim actually say it? And is it actually false? Is there a reasonable probability that both of those things are true? If both of those things are reasonable, there's a reasonable probability that both of these things are true, I think that meets that concrete evidence standard. That may trigger the in-camera hearing. Once we get to the in-camera hearing, the standard that the trial court needs to apply, which this court has not set what that standard is yet in that hearing, should be clear and convincing evidence.
You keep using reasonable probability, which is from Stanaway.
Yes.
So I'll ask you the same question, understanding that it's analogous, it's not in the same context.
Yeah.
But what are your thoughts on the court adopting that and replacing concrete evidence?
I think it is a great analogy, and it would greatly help trial courts in applying the Stanaway framework to the way that Hackett works. I think the fact that it addresses a discovery issue is immaterial. I think what it helps is, one, Stanaway helps us establish how do you trigger that in-camera review by a judge. What is that threshold showing that we need to establish? And it's something that the trial judges are very familiar. We see a lot of times trial judges floundering with this issue in applying Hackett. So I think as the amicus from the Attorney General points out, it would help to have that body of law for the trial courts to go back and to be able to rely on in order to determine whether that threshold showing of relevance has been applied.
Why isn't the alleged perpetrator's denial or claiming it's false, why isn't that enough to meet that standard? Or do you think it is?
I don't think, at the end of the day, each case is to be evaluated case by case. I think generally it is not enough. I think that oftentimes in cases like these, particularly when you're talking about sexual assault involved with, at the time, young people on a college campus, that the way that the defense comes out is often, it was consensual, no it wasn't. But that this is the core nature of it. That's what gets to the fact that these matters are resolved by a trial. And so we're not allowed to have a trial within a trial. So when that's the mere proof to show that it was false, I think that that is insufficient generally in and of itself.
Is that an issue unique to a false allegation regarding consent? As opposed to say, it never happened?
Is that a unique?
Well,
Could you re-ask it just a little bit?
I guess, like you're saying, in this, the problem with relying only on that is then you're gonna have this sort of trial within a trial. Somebody's gonna say, was consensual, it wasn't. And I understand your point about that, about whether or not somebody saying it wasn't, or it was consensual may not be enough to even sort of get to the in-camera. But what about, I mean, that's a harder case to me than where it's, this didn't happen. You know, I wasn't, the act, the whatever, prior sexual conduct didn't happen.
Didn't happen.
As opposed to, it happened, but it was consensual.
Right, I agree. I think that I think it is harder between when everyone agrees that there was sexual activity that occurred, and the question is whether or not consent occurred, than whether there's some sort of proof that it didn't happen at all. Yeah. So, and I think
Counsel, can you help me understand? I asked your opposing counsel whether there was an evidentiary hearing, in-camera hearing. She said there was. That
Yes.
Both sides agreed. It would be conducted apparently by just submitting documents to be reviewed by the court in camera, which is apparently all that occurred here. Do I have that? Is that accurate so far?
So I would disagree that an in-camera hearing actually occurred in terms of in following the Hackett procedure. If you look, I quoted it in my brief, when you look at what the prosecutor's agreeing to, she's indicating as an offer of proof, we would agree to submit some documents to the court for the court to determine whether we should even have an evidentiary hearing. And in fact, appellant in their application to this court on page 11 said, quote, by agreement of the parties, the circuit court reviewed information about the 2008 allegation in camera as an offer of proof. So appellant's changing their characterization of what happened in the trial court now. Even on application here, they acknowledged what happened was an offer of proof. It was not the actual in-camera
Help us
hearing.
understand what's supposed to happen under Hackett at an in-camera evidentiary hearing. Sounds like more than reviewing documents. I mean, that would be, I was a trial judge, that would be in-camera review.
Correct.
That's all that appears to have happened here, right?
Correct, just an in-camera review of the documents themselves. I think then what Hackett anticipates is that there's an actual evidentiary
In
hearing.
camera, in a
In-camera.
private setting, not a public setting.
Exactly,
It's sensitive material or
Exactly.
information. And then the judge would make some determinations
yes.
after hearing what, testimony or receiving other written evidence?
Correct, I think any of those things. Ultimately, if the defendant is successful in obtaining the in-camera hearing, it's up to them to decide what evidence to present to the court.
I read, I mean, it's been a little while since I read this, but I read the judge's ruling in this case to essentially defer some of the Hackett findings down the road to trial. Is that an accurate
Yes.
supposition or interpretation of what happened in this case?
Yes, I think that both the trial judge indicated that she would defer some of these decisions to see how evidence came out at trial, and also to let the jury themselves decide when Hackett established that, no, the judge needs to perform some sort of a gatekeeping function here, and rather than perform that function, she abdicated it to the jury.
Do you think that can happen without hearing from witnesses?
Do I think what could happen
That
without?
the judge could perform her gatekeeping function without actually hearing from the witnesses who are going to then testify at trial?
Perhaps, but I think then when it comes up on review to a higher court, there's no deference owed to the trial court. I think here there's no deference owed to the trial court in terms of any determination that was made, because it was all based on reports. So this court and the Court of Appeals are in equally of a good position to review the decision that was made as the trial court was, because there was no credibility determinations made. It was all made based on a reviewing of police reports.
I mean, one of the points I think in Hackett is to help preserve for appellate review
Correct.
what the evidence was and what the decision-making of the trial court was based on.
Correct.
I guess that's my question to you. Do we have a sufficient record here for us to,
I think you have a sufficient record here to decide whether or not there was a sufficient offer of proof. I don't believe that the offer of proof was sufficient, but even if this court disagrees with that, then I think the next step in the remedy is it gets remanded for an evidentiary hearing.
Counsel, I'd love to get back to sort of the burden of proof and your contention that at, whether we adopt Stanaway or whatever we do, that it should be a heightened standard. I guess one of the things I'm challenged by is we already have a heightened standard just to even get to the in-camera review and get the right to sort of get over that hump. So aren't there enough protections there to balance the goals of the rape shield statute, but also the right to put out a defense?
So I would disagree that it's a heightened standard to get an in-camera review. It's a standard of showing the evidence is actually relevant. Relevant. It's kind of the same thing that the court does in an offer of proof under a 404B motion. Is it actually relevant? Is it material and probative for the thing that they say it is? That's what the first question in Hackett is.
Sure.
Second question is now, what do we do here? And this court has actually answered that question. So the purpose of a standard of proof is to allocate the risk of error between litigants and reflect the relative importance attached to that decision. So this court in People v. Taylor in 2002 put on the prosecution the burden of clear and convincing evidence to rebut the presumption against a juvenile receiving a life without parole sentence. And it relied on Herman and McLean versus Huddleston, that's 459 U.S. 375, 389, to come to that decision. And in that case, the U.S. Supreme Court held proof by clear and convincing evidence is the appropriate standard when particularly important individual interests and rights are at stake. Article 1, Section 24 of our state's Constitution confers on crime victims the right to be treated with fairness and respect and dignity and privacy throughout the criminal justice system.
Right, but normally initial evidentiary rulings are preponderance of the evidence.
Ordinarily, but the Rape Shield statute and the Constitution of our state infers special rights on crime victims, and particularly victims of sexual assault. It is the existence of the Rape Shield statute, as well as that particular portion of the Michigan Constitution, that requires a heightened standard of proof that's different than, for example, a regular 404B motion. It is the presence of those particularly important interests and rights that are present in these cases that require the higher level of scrutiny by a trial court in the in-camera hearing.
Is the information that defendant is trying to get introduced relevant to this case?
No.
Why?
It's not relevant. First of all, there's different theories of relevance that were admitted. When you look at the offer of proof, they said it's admissible under 608, 404B, or 406. I don't think the degree of any similarity that occurred between the two incidents rises to the level of habit, so not even going to address 406. We've already discussed to some degree whether or not it even establishes that falsity, where it could come in only through cross-examination without extrinsic evidence under 608.
Yes, there's definitely evidentiary potential barriers in the future, of course.
404B comes down to the degree of similarity. And again, this court has talked about where if it's based on similarity, it needs to be striking similarity between the conduct that we're talking about and the other stuff that comes in. And so, first of all, they're saying it's a similarity in false reports of criminal sexual conduct. She's never acknowledged that it's false in either circumstance. And the two actual circumstances are nothing alike with each other. She knew one of the two perpetrators as a close friend, someone she'd been romantically...
So all that analysis, aren't those the things the trial court should go through? Isn't that what...
So that's exactly what the trial court should go through, but it needs to do it at the offer of proof stage. I mean, it does it at both stages, but there's a weeding out process that happens in the offer of proof. A lot of this extra information that we're having is coming up on appeal. If you look at the offer of proof itself, it's quite paltry. There was none of this line making between what the rule of evidence is and demonstrating what its actual relevance is. That didn't happen here. And so, yes, it does need to happen. The trial court needs to consider it. The trial court first needs to review that offer of proof. If the trial court says, all right, on its face, I think that meets that standard, let's have an evidentiary hearing. At the evidentiary hearing, then, the defendant needs to provide clear and convincing evidence that what they claimed in the offer of proof is actually the case. So we would, at this point, ask this court to rule that a defendant's offer of proof must provide that realistic and substantial possibility that what they're claiming is true. That is, that a statement was false or any other theory of relevance that they're submitting, and hold defendants to the same standards that would be held if they're bringing up something under, for example, 404B, that a prosecutor would be held to. We also ask this court to direct trial courts that they're to apply the clear and convincing standard during in-camera hearings conducted pursuant to a defendant's adequate offer of proof. And finally, we're asking this court to affirm the Court of Appeals decision in this case, find the defendant's offer of proof for the purpose of triggering an in-camera hearing was insufficient. I waive the reminder of my little bit of time, and I thank you all.
Thank you.
I'd like to address just two things. Justice Viviano's concern about the in-camera hearing, and then, of course, the standards. I think there was an in-camera hearing. I think it was
There wasn't an evidentiary hearing.
There was not testimony, no.
Well, there's in-camera review of the documents you submitted.
Right, which was,
But heck, it says in-camera evidentiary hearing for a bunch of reasons, but one of which is to establish a record of the evidence for appellate review of the trial court's ruling. And doesn't the trial court need to hear some testimony during this in-camera evidentiary hearing?
I think that in most cases that would be preferable, and there were probably some reasons that the prosecutor suggested doing it on paper here. But we do have what Judge Lightvote reviewed, so.
No, I understand.
So we can see
I have
it.
those materials here, police reports, et cetera.
Yes.
Why is that not the offer of proof? What was if that's the evidence for the in-camera evidentiary hearing, what was it submitted for the offer of proof?
The offer of proof was the statements in the motions about what would be proved at the evidentiary hearing. There were statements in the motions about the two suspects denying that the encounters were anything other than consensual. There was information in the motions about the friends and the other people at the party talking about the behavior of the complainant.
So I just want to understand this. You're asking us to overturn what the Court of Appeals has done, and without any court ever hearing whether any witness would actually testify to whatever is said in these police reports, and rule that your witnesses get to testify in whatever fashion they're going to testify, which no one knows because there hasn't been an in-camera evidentiary hearing to see how they would testify.
I agree it was an unconventional approach, but that was what the parties agreed to here, Your Honor.
Is that the way this kind of sensitive information is supposed to be handled?
I personally probably would have preferred an evidentiary hearing, but there are probably reasons why.
Can this court do anything, if we were to rule in your favor, could we do anything other than remand the case back to the trial court to perform the in-camera evidentiary hearing that our precedent requires?
Yes, I think you can affirm the trial court because this functioned as the in-camera evidentiary hearing. The trial court took evidence. She made her determination.
But if we do that, we're putting our sanction on a process that violates our own precedent, which means we're creating a new precedent for cases in the future. Do you think that's a good idea? You just said it's not a good practice. What happened here?
By agreement of the parties, they decided to do it this way. And then when the court when Judge Lightvote made her ruling, the prosecutor didn't object. She didn't say, hey, no, we need to have an evidentiary hearing now. They didn't even appeal that issue to the Court of Appeals. So I do think we are stuck with it here for better or for worse. And then the only other thing I wanted to address, unless Justice Viviano, you have more for me on that.
I don't. I mean, your last comment, I mean, we're only stuck if this court gets to decide how to proceed, so we might not.
Well, and I mean, if we need an evidentiary hearing, we need an evidentiary hearing. But under the way this has now been presented to the court, this was all agreed upon and it wasn't objected to.
I struggle with a case where we're asked to come up with all kinds of standards of proof that should happen at the end of an evidentiary hearing that never happened. It's very hard for me to, we're not supposed to do advisory opinions. We're not supposed to rule on things that aren't before the court and may never be before the court in this particular case. And so I'm trying to figure out what is this case that's in front of us, and how should we get this case that's apparently gone a bit off the rails back on the rails? Understood.
And that sort of leads to the standards of proof issue. And in the spirit of Justice Bernstein liking to keep things sort of simple, I don't know why we don't apply 103 and 104 to Evidence Rule 103 and 104 to this. I mean, that's obviously the most straightforward thing to do. Evidence Rule 103 talks about offers of proof, and all that means is you make the substance and the character of the evidence known. Some evidence. Who's going to say what? These are the witnesses. They're identified in the offer of proof, and this is what they're going to say. That's all the offer of proof needs to be, establishing that prior sexual conduct occurred and some evidence that it was false. And then, of course, at the in-camera hearing, let's keep it simple. Let's apply 104A like we do in all kinds of other preliminary determinations, hearsay and Walker hearings and Turner hearings, all those things. They just require a preponderance of the evidence. So thank you.
Thank you. Thank you both. The case will be submitted.